A very good evening to Dr. Rizal. This is me, Tamara Anak Perempuan Sudir, metric number A155797. I was given the question 2 from week 14. And first I'd like to read out the question to you, Doctor. So, the question sounds like this. Aida telah membeli sebuah mesin jahit bernama Songir daripada kedai Shingen dengan harga RM10,000. Pada awalnya, Aida memandang mesin itu sebelah mata sahaja kerana jenama itu tidak pernah diketahuinya. Tetapi Shingen telah memberikan representasi yang sangat meyakinkan tentang kecanggihan mesin itu kepada Surya, iaitu kakak Aida yang menemani beliau. Tambahan pula, Shingen berwajah kacak dan berbadan sado. Maka termakanlah Surya dengan representasi Shingen. Surya telah memujuk Aida untuk membeli mesin itu. Namun begitu, belum sampai seminggu mesin itu mula membuat hal. Apabila Aida mengadu kepada Shingen, beliau terkejut apabila mendapat tahu yang mesin itu sebenarnya mesin terpakai. Aida yang merasa tertipu telah membuat aduan di Tribunal Tuntutan Pengguna. Malang bagi beliau kerana kebetulan kes beliau didengari oleh Hortas, Abang Shingen, dan akibatnya beliau telah kalah dalam kes itu. Aida yang merasakan wujud pakatan antara Shingen dengan Hortas telah membuat laporan polis tentang penipuan Shingen dan salah laku Hortas. Jika kes ini berakhir dengan pendakwaan terhadap Shingen tetapi Hortas tidak didakwa, sebaliknya dipanggil sebagai saksi pendakwa, manakala Surya pula hadir sebagai saksi bagi pihak Aida, bincangkan isu-isu di bawah. Pertama, sama ada Hortas merupakan rakan sejenayah dan apa kesan keterangan beliau. Allow me to present in English, Doctor. So first, I would like to discuss who is an accomplice. So it is crucial for us to determine whether a witness is an accomplice or not. And in determining who is an accomplice, it has been laid down by Lord Simmons in Davies and DPP, and held that there are 3 categories of persons who fall under the term accomplice. First would be participes criminis, who are parties to a crime. Second, receivers in respects of thieves from whom they receive goods. And finally, parties to a crime which constitute similar facts, crimes which are so similar that they prove the system or intent and negative accident. So let us first look at 2 Sarkar in the page 1280. It gave us a general statement saying that the point of determination appears to be whether a witness entered into a conspiracy with the sole object of detecting and betraying it, or whether he is a person who concurred fully in the criminal design, whether he was there from the beginning. That is my understanding of that. With his co-conspirators for a time and joined in the execution of these till out of fear or some other reason he withdrew from the conspiracy and gave information to the authorities. If he extends no aid to the prosecution until after the offence has been committed, he would be an accomplice. So this generally, the first, the case of Davies and PP, and secondly 2 Sarkar in page 1280 defines who is an accomplice in general. So let us look at a few Malaysian decisions on who is an accomplice. So let's look at Gopal Sriram's decision in Sabaruddin bin Nun and public prosecutor. Gopal Sriram said that in our judgment, the correct test for determining whether a witness is an accomplice or not is laid down by Thompson CJ in Chow Chong and public prosecutor. The true question, he said, however, was not the technical one of whether the witness could have been convicted for his participation in the offence or if he had been prosecuted. The actual question, the true question, was whether, having regard to all the circumstances in the case, his evidence was to be regarded with suspicion and as probably so tainted as to invite or not to demand corroboration before it was accepted. So what Gopal Sriram in Sabaruddin bin Noor said that this witness who is an accomplice, his evidence is to be regarded with suspicion and is to be requiring corroboration before it was accepted. Let's look at the next case. In Goh Kyok Pong and Public Prosecutor 1954, the judge said, is there any evidence upon which I can properly rule the witness was a participant in the offence? So there is still a lot of grey areas as to whether the accomplice was a participant in the offence or something else. In our situation, I think that based on my understanding of these previously discussed cases, the Hortas is not an accomplice. However, he may have been an accessory to fact. An accessory to fact is someone who does not procure in the commission of the crime. However, he is one who actively assists in the accused in concealing the crime as an accessory after the fact. So let's look at Augustine Paul's decision in Francis Anthony Sami and Public Prosecutor. The evidence in this case reveals that PW4 had no prior knowledge to the intention of the accused to commit the crime. Thereafter, he assisted in the accused in concealing the crime. The question arises whether on these facts he can be termed as an accomplice. Again, we look back at the case of Davis and Director of Public Prosecutions. It was held that those who are participes criminis in respect of the actual crime charged, whether as principals or accessories before or after the fact, are accomplices in the crime. In explaining the roles of persons laid down in the categories of such person was in the Law of Evidence by the book of Law of Evidence by Woodruff and Ame Ali, 16th edition, volumes 4, states a principal of the first degree is one who actually commits the crime, and a principal of the second degree is a person who is present and assists in the perpetration of a crime. An accessory before is the one who counsels, incites, connives and encourages or procures the commission of the crime. Everyone is an accessory after the fact to a felony who, knowing a felony to be committed by the other, receives, comforts or assists him in order for him to escape punishment from arrest for the felony, or having in custody for the felony intentionally and voluntarily suffers him to escape or opposes his apprehension. In this case, the PV4 neither committed the crime nor did he assist the accused in committing it, neither did he procure his commission. As he assisted the accused in concealing the crime, he was clearly an accessory to fact. So if it is proved that Hortas actually assisted our Shigen in concealing the crime that he did, which was selling a second-hand good in the name of a first-hand good, he will be an accessory to the fact, thus he will be participes criminis. Okay. Augustine Paul in his book Evidence, Practice and Procedure stated that although an accessory to a fact is not an accomplice, his evidence is to be considered the same as the principals as an accomplice. This was explained and decided in Harcharan Singh and another and Public Prosecutor. Okay, next we go to whether Surya was a saksi berkepentingan, sama ada Surya merupakan saksi berkepentingan dan apakah kesan keterangan beliau. Saksi berkepentingan, I believe, is interested witness. So let's look, who is an interested witness? An interested witness is any witness who had interest in the matter. The legal presumption for such an interested witness is that the person is to be trusted unless cogent reasons can be advanced, such as the statement could affect the probative value and the weight of the evidence. This is stated in the case of Balasingam and PP. Next, in the case of PP and Fung Chi Chong and Lim Boon San, the court held that it is the duty of the prosecution to establish that the complainant had no motive to falsely implicate the accused. We look finally in this book, Law of Crimes by Ratan Lal and Dheeraj Lal, second edition, at page 1455, stated the following in respect to related witnesses. Related shall not be equivalent to interested. The term interested postulates that the person concerned has some direct interest in the result of the litigation, such as interest in decree in a civil case or in seeing that the accused is punished. A witness who is a natural one but a relative of the victim cannot be termed interested. So I am still confused as to whether there is actually a definition, a legal definition for an interested witness. However, based on the judgment in Balasingham and PP and the reading in Ratanlal and Dheeraj Raj, I can conclude that Surya can be concluded as an interested witness, and her statement is to be trusted unless it could affect the probative value and the weight of the evidence. Thank you.